Hi. So we'll be talking about merger and acquisition. Now, merger and acquisitions are a very wide topic in the Indian landscape and also outside. We will be talking about a recent change that Ministry of Corporate Affairs had brought into the fast track mergers under section 233 of the Companies Act 2013. Now, under the fast track merger, the Ministry of Corporate Affairs have revised the applicability on would be covered under the route of fast track mergers. Earlier it was only small companies or startups that were allowed to do fast track mergers. Now when we say fast track merger, it means that you will be allowed to do mergers without going to NCLT and filing a petition. You can do it in a shorter time span with the ROC and RD's approval, as the case may be. Yeah. And so now the ambit is increased. So let's try to understand holistically what all companies are getting covered under fast track mergers under section 233 of the Companies Act 2013. Or more small companies. If you are a small companies, you can do a fast track merger. Now, definition of small companies, that what is a small company and what is a not a small company, is in basis of turnover and other criteria, which are again mentioned under section 2 of the Act. So you can identify if you're a small company or not through going through that section. Okay. Holding company and its wholly owned subsidiary company. If there is a merger between a holding company and its wholly owned subsidiary matlab all 100% shares are held by the other company. So that was also earlier covered under the fast track merger. Just replicating that holding and WOS can merge through fast track mergers. Okay. Two or more startup companies also can go under fast track mergers. This came into effect from 1st February 2021 under Rule 25(1)(a). So this was effective from 1st February 2021 that if you are a startup company, you can go through fast track mergers. So Rule 25(1)(a), which was effective from 1st February 2021, said that if there is a merger between a startup company and a small company, then also it can route through it can route through fast track merger under section 233 of the Companies Act. Increasing the ambit of fast track merger, recently Ministry of Corporate Affairs have came up with Companies Compromise Arrangements and Amalgamation Amendment Rules 2025 dated September 4, 2005, where they said that if you are an unlisted company and you're doing a merger with an unlisted company, then you are covered under the fast track merger route. But they said that they have given certain uh, things which you have to follow. So if there's a merger between unlisted company and a unlisted company, here section 8 companies, NPOs are not covered. Exception is for section 8 company. If you are an unlisted company and where such unlisted where such unlisted company has in aggregate out of loans, debentures and deposits have the outstanding loan of maximum 200 crores. Okay, maximum 200 crores if you have a loan, and both the conditions should be satisfied. Outstanding loan of maximum 200 crore and you have made no default in the payment of these referred above loans and deposits. Then what you can do is you can go through a fast track merger under 233 of the Companies Act. Okay, so you are two unlisted companies, you have loans of maximum 200 crores, and you've made no default in payment of these loans. But when have you not made default? That is also defined. So you've not made any default in the payment of these loans on a day which is a day before the date of sending notice of merger to ROC and OL. Now, whenever you decide for a fast track merger, you take a board's approval, you pass a shareholder resolution, then you have to file a notice to ROC and OL that your company is going into the merger with certain details in Form CAA 9. Now the law is saying that you have not made a default in payment of these loans on a day which is 30 days before the sending notice of merger and notice of merger to ROC and OL. So if you have not made a default 30 days before the date of sending of notice to ROC and OL, then you are only eligible. So when will you see that you have not made a default in payment of this outstanding on a day which is 30 days before sending notice of merger to ROC and OL, and also on a day on which you are filing the final scheme to central government and ROC in form CAA 11. So on a day on which you are filing form CAA 11, and on a day on 30 days prior to the date when you're filing from form CAA 9, which is a notice of merger to ROC and OL. On these 2 days, both of these 2 days, you have to see that you have not made any default in the payment of outstanding loan, debentures and deposits. Now, such certificate should be obtained from the auditors of the company. That company meets this criteria. What criteria? That company meets the criteria that it has not made any default in the payments of loans, debentures and deposits on a day which is 30 days before the day of sending of notice of merger to ROC and OL in form CAA 9, and has not made a default in payment of loans, debentures and deposits on a day of filing of merger scheme to central government ROC or OL in form CAA 1. Such certificate should be obtained from the auditors and should be filed in form CAA 10A. Okay, so that is the condition if two unlisted companies are going for merger. Okay. These rules, which came into effect recently in September 2025, also allowed a merger between listed or unlisted holding company and listed or unlisted subsidiary company. Okay, if you are a holding company and if you are a subsidiary company, you can do a merger through fast track route even if you are a listed. But there is a very important thing to be noted, which is very logical also. If the transferor company is a listed company, then you cannot go through fast track merger routes. Now, the logic is that when a merger happens, the existence of transferor company, all the assets, liabilities goes into the transferee company. So technically the existence of transferor company comes to null. So that is why a listed company cannot, get wiped off just like that. So it's very logical that you can do a merger of a listed and unlisted company which have a relationship of holding and subsidiary, but the transferor company in that case should not be listed. A transferee company should be listed only. Clear? This is also very important to understand, which came recently through September 2025 amendment, which says that if there is a merger between two companies, which have a same holding company, that is you are a member of same family. So in that case, a merger can between such subsidiaries can happen. This representation could show you that a merger between subsidiary A and B can happen because they have a same holding company. Again, provided the transferor company is not a listed company. This is applicable throughout because I've explained you the logic that the existence cannot be null of a listed company suddenly. So the transferor company in any case cannot be a listed company. this structure also, which represents that if there is a company A which has a wholly owned subsidiary company B, then company B has a subsidiary company C has a subsidiary company D. So if there is a merger between B, C and D, then also it can happen through fast track mergers, because ultimately the holding company, company A, is same. Company B will have a holding company, company A. Company C will have a ultimate holding company as company A, and company D will also have a ultimate holding company as company A only, right? So in that case, if you can see where the where the companies are children of same parent company, when your parent company is same, you share a relationship of holding and subsidiary, or a subsidiary, then a merger between you can happen, provided again the transferor company are not a listed company. If company B is getting merged into company C, and suppose company B is a listed company and it is also a transferor company, company B, if it is a listed company and a transferor company and is getting merged in transferee company, company C, then it cannot go through fast track merger, because there is a provision which says that a transferor company should not be a listed company. Correct. So now this is all about what the recent amendment keeps. I hope you've understood it. Thank you.